Sloan there. Well, for more on just how the Act works in practice now, I'm joined by Joydeep Hor, Managing Principal at People and Culture Strategies. Joydeep, welcome once again. It's kind of a very quick delve down into this legislation, which, let's be honest about, it hasn't had that long to bed down. The idea of a review, first and foremost, kind of behind closed doors, what to you does that say about transparency, open discussion?
Yeah, I think what it says is that industrial relations legislation is, at the best of times, highly political and politicised legislation, particularly the genesis of this legislation, which was the Brave New World having buried the work choices legislation. I can understand that the government is quite protective of the criticisms of it. Having said that, it was pretty radical reform in many ways, and a review is necessary. I find it very interesting, though, that these criticisms have surfaced quite recently in circumstance where at the last election myself and many others were saying, how is it that either party is getting away with neglecting industrial relations reform as a major issue? Is it really the case that we're now looking at industrial relations as the excuse or perhaps the easiest scapegoat around some of our broader economic woes?
Is it because practically the amount of those who are members of unions has been on the steady decline? So, when rubber hits the road, we do get those outbreaks. The instance of Qantas already talked about this week yet again, but on a broader footing, even the mining industry, those who are signed up paid members, it's in the decline.
It is, and it has been. And one of the promises of the Fair Work Act was that through the introduction of good faith bargaining laws, there would be less disputation. Employers wouldn't be able to walk away from that whole bargaining process. I think if the union movement's speaking candidly, they'd say that the Fair Work Act has not delivered the benefits through the good faith bargaining laws that were promised.
Because what was at the heart of that? What hasn't been necessarily being brought together adequately on that front? I
think that the laws require bargaining, but they don't require agreement to be made, and clever employers are saying, well, we're happy to talk till the cows come home, but if there's nothing compelling us to reach an agreement, we'll just keep working through such a process.
There's a stalling tactic there. I mean, how does it give effect to the kind of the spirit of the Act?
Well, I think that's certainly what a lot of the people on the union side of the fence would be saying. A lot of the employers would be saying in response, well, the economy speaks for itself, our business circumstance and challenges speak for itself, we've got nothing more to give. What I think has been interesting is that there has actually been a less amount of industrial disputation. Of course, you're always going to get your high-profile Qantas type scenarios, but I don't think there's been as much industrial disputation as certainly there have been at other times in Australia.
Well, just walk me through that one, because I mean, it kind of is a flashpoint for people out there travelling, wondering, are we going to get on a plane or not practically? But when it comes to both sides saying, really, we've gone as far as we can, now we're forced into taking action, does that imply that the good faith bargaining has come to an end, or what is the next step? Does it then get escalated, and typically to what level?
Yeah, well, I think when a union takes the industrial action that it is lawfully entitled to take, and there are various requirements which make it lawful as opposed to unprotected or illegal, the pressure certainly shifts to the employer in terms of how much pain can it withstand. But employers will only be able to give as much as they can give, and so it's a judgment call for them in terms of, well, their brand and their customer disruption and competitors picking up the work and whatever else. So in terms of what will be the breakthrough, these things very rarely carry on forever. There will usually be something, whether that's mediation, whether that's through the assistance of the tribunal to try to break through.
Because what's the trigger for them to step in and interrupt proceedings typically? When does the tribunal say, enough of that rancour, we will mediate?
Well, it's actually quite interesting. The Fair Work Act has a lesser role for the tribunal to intervene in those circumstances than was the case under work choices or predecessor legislation. It is, absolutely. Yeah. And many employers at the moment would be saying, we want some external input, but we're struggling to get there. So short of us challenging whether the industrial action is lawful or not, we're just in this stalemate.
Are you saying the bar is raised under the Fair Work Act so that there are more hoops to jump through until you can call on the tribunal?
Until you can call on the tribunal, unless you're accusing the other party of not bargaining in good faith, in which case you go through the bargaining orders path and whatever else. In extreme circumstances, the tribunal can make these forced determinations, but they've been Absolutely few and far between since the introduction of this legislation.
What, to your mind, if we can just broaden the scope of the discussion and talk about maybe some of the adverse action claims, whether that's been exploited or not, just set out the framework and the environment for that type of an action.
Yeah, so general protections claims, or adverse action claims as they're known, were introduced as a result of the Fair Work Act to enhance employee rights and employee protections in the workplace. What we have seen happen in practice is that a lot of people are using them as de facto unfair dismissal claims in circumstances where, because of their remuneration level, they wouldn't be able to bring an unfair dismissal claim. Employers are really swimming in terms of, this can go anywhere. We can have people earning $500,000 salaries sue us for adverse action. It was never intended to be a playground for the rich and famous.
And what's the tribunal coming back and saying on that level? Well,
the federal court is the jurisdiction in which these cases are being tested. They're trying to, I guess, bring it more in line with the intention, but on its face, this is rife for exploitation, and certainly there have been some pretty critical cases which would make any proper, genuine reform of this legislation take stock and say this has gone way beyond what was ever intended.
Are you saying the bias is towards what? At the point where the federal court makes its ruling?
Well, it has to go through a conciliation process, and strategically what's happening out there in practice is that people are saying, well, let's get it into conciliation. We're probably going to be able to leverage some settlement at that point, because who's really going to want to incur all the costs and hassles of a full decision in the federal court and all the time and costs associated? Is there an argument to say the tribunal would be best served to hear these claims? And why even tie up the federal court? It's got its caseload is full to bursting. Yeah, absolutely. I mean, there are some constitutional challenges with that, but I don't think that was something that was thought through, or whether it was thought through and has been exploited since its introduction. It's too late now.
Judith Stone was saying, look, this should be going to the Productivity Commission, this review. It shouldn't be something that a minister plucks the eyes and the teeth out of. Is that a fair call, given the whole broader theme at stake with interest rates and jobs and the uncertainty over whether we can, in this environment, perhaps even justify layoffs in order to bring about greater productivity?
Yeah, I understand and have a lot of sympathy and support for that argument. I think, though, that the Fair Work Act is very broad in terms of what it covers. It deals with matters such as industrial action, it deals with matters such as bargaining, it deals with unfair dismissals, awards, safety nets. It deals with everything that that is associated with people and people management.
And you wouldn't disagree with any of those and say the boxes have been ticked pretty comprehensively?
Well, they're all there.
Yeah.
As to how effectively they are working, it will very much depend on who you speak to. Australia is facing some challenging economic times at the moment. It's understandable that there's a focus on productivity and the interplay between this legislation and productivity, but the Fair Work Act goes far beyond those things.
Well, because you're at the forefront of it. So rather than fence sitting, just a final for you, mark out of 10, since its implementation, are you saying this is a step forward in the round for employment relations and for productivity, or a step back?
I think that as far as a rebellion or a rebuttal of the work choices legislation, it's certainly moderated. It's fairer legislation, there's no doubt about that. But it's by no means what Australia needs, and it's not the best framework. There's a lot of scope for improvement, and I was saying that at the time of the last election. So, I mean, don't want to be giving marks out of 10, but there's a lot of work to do.
Will you be inputting into the review process?
And certainly we're talking to a lot of clients about working with them on substantive input. Yeah, absolutely.
Joydeep, best of luck. Come back, update us in the fullness of time. Thank you.
Thanks, Gus.
Right. Managing Principal there at People and Culture Strategies, Joydeep Hor, no less. Well, let's now